This is episode number 7 of the Inland Empire Workers' Compensation Lawyer live stream and podcast. I'm here with my co-host, Georgia Boado. My name's Alexander Napolin. We're workers' compensation lawyers in the Inland Empire. So subrosa evidence, subrosa surveillance evidence, social media, what is it? And why do injured workers need to know about it?
Subrosa is a Latin term, and it literally means under the rose, which means hidden surveillance. And who does this? The insurance companies. Sometimes the defense attorney will request it. Sometimes the adjuster will request it, but it's done by the insurance companies to monitor you, to surveil you, to see if they can find anything that will help their claim and completely obliterate your claim. Your medical reports, everything that you've worked so hard on with your attorney can go down the drain in a minute if the subrosa proves to be effective, if they get something on video that they can send to a doctor that they can use in court. So that's what subrosa is. What do you think about subrosa, Alex?
So let's say you're not working. Let's say the doctor's taking you off of work and is giving you work restrictions. And now you're out and about on the weekend and you are offered a soccer game or a sporting event to go to. And you go and clearly in the open public violate your work restrictions that are keeping you from working, that you're stating to the doctor that you have certain limitations and telling your primary treating physician that you need certain work restrictions because of those limitations. And then you're going and violating it outside in the open public where the insurance company could have an investigator that's taking video surveillance of you that can then later be introduced to the judge to discredit your testimony as to your limitations during that time period, and it could invalidate your temporary disability payments. So it's very important that if you're injured, you understand that the insurance company can be surveilling you. This can be an issue, and you need to be careful.
They want to see what your daily activities are, and as Alex mentioned, whether or not you're being truthful about that. Now, you could have said to the doctor, I can't walk for more than 15 minutes at a time, or doctor, I can't sit for more than 20, 25 minutes at a time because my back hurts. Doctor, I can't take out my trash. Now, if you are having good days and bad days, it's very important that you also tell your doctor that and say, doctor, I usually can't walk 15 minutes at a time. I usually can't do this. Because if you're saying you can't do it, and now they hired a private investigator and they watch you walk your dog for 30 minutes, they're going to come back and say, hey, this person said this on the record, in a medical report, possibly in their deposition under oath. So that's something we'll talk about as well. And now we have video of them doing exactly what they said they could not do. So it's very important that when you speak to the doctor, when you speak and give your testimony in a deposition, that you also use the terms sometimes. I usually can't do this, because if you do have a good day and you're able to do it, it's very hard to convince the judge or the doctor that's reviewing the subrosa video, the surveillance video, that, oh, you just had a good day and that day you could do it, and that's when they did surveillance on you. It's also important to note that because of this reason, surveillance is done more than one day. It's a period of days. It's not only one day. They take multiple days of surveillance on you, and then they compile that together into what they believe is going to be better for their claim. So once again, it doesn't just have to be the injured worker that the performance of surveillance on. It could also be working conditions, different things that might play a part in your claim. So that's really important to note, those things. Surveillance probably isn't happening on you, but it's you should be open to the possibility that it is very, very, very possible that they do perform surveillance on you at some point if they have any questions or doubts about your injury and how serious it is.
So we don't exactly know if it's, how often a certain carrier is doing it as plaintiff's attorneys, because we only know when they disclose it. And in many cases, they don't ever disclose it because the case never gets close enough to trial where witness lists have to be disclosed.
Right.
The case is maybe their subrosa evidence somewhat supports the claimant's situation, so we never see it.
Right.
But the adjusters will, if they suspect that there's something fraudulent going on. It may be a tip from the employer that gets the adjuster to investigate the claimant further, or it could be that they have some concern about the medical reporting that they've seen. Maybe they've seen some inconsistency between two different doctors.
Right.
So they're looking and fishing around, and they might not be hiring somebody to investigate your claim and spy on you, but they're probably spying on you themselves with their computer.
Right.
Just something that can happen. And I'm calling it spying, not surveillance. But the adjuster could be called to the Workers' Compensation Appeals Board to give their testimony as to what they saw on your social media pages, and social media being a place where you're going to post things that might violate your restrictions.
Also, maybe the objective findings are not consistent with the subjective findings. So what does that mean? Objective findings are tests that are performed by the doctor, range of motion tests, or MRIs, or X-rays, or nerve conduction studies. Those are objective, right? They're performed, and whatever the result is what the result is. Subjective is what the injured worker is telling the doctor. Maybe the injured worker is saying, my back is killing me, I can't sleep all night, I have constant pain, it's at a 10 out of 10, and they do an MRI, they do X-rays, they perform those studies, and it all comes back negative. Well, that's very inconsistent. It might be that either it's something that you can't find, it might be a medical condition, which do exist, that are very hard to pinpoint and actually find objective findings for, but it could also be that the injured worker is lying. So the adjuster at that point says, well, there's a lot of subjective information given to the doctor by the injured employee that their life is a mess. They can't continue. They can't perform their regular daily activities. But we don't have any objective findings. This doesn't make sense to me. It doesn't add up. I want some further investigation on this. So they might require a private investigator, right? Something
Absolutely,
like that.
Yeah. Well said. So be aware that if you have any of these issues going on, you're extended on your temporary disability, or your diagnostic testing is maybe, well, look, if you're lying, don't keep doing it.
Right.
But sometimes you're not lying. Sometimes it may be that you're posting something on social media and you're not lying about your condition, but the adjuster could try to paint it in a way, because you have to understand that the other side, the adjuster, the insurance company, the people working there, they don't know what you know about your capabilities. They only know what the doctor reports, what they see on paper, and what you're doing without much context.
Social media doesn't always tell the truth, and what you think you're posting on social media might look different to someone else. So that's very, very dangerous for you to do while you have a workers' compensation claim open. There's some things you can look for. Obviously, they're going to camp out, and they actually show up to your house very, very early in the morning, so they can start the surveillance very early in the morning. And it's kind of like a stakeout. When you see in the movies, they're trying to catch the bad guys. Well, right here, they think you're a bad guy. They think you're lying. They think they have reason to believe that they can catch you in a lie. So they will be there super early. They're in their car usually. And, if you see a car that hasn't moved for a long time and there's someone in there, maybe investigate, especially if you're part of the neighborhood watch, right? Obviously don't go up to them, but kind of keep an eye out. If you're going for a walk and someone's following you, best case is, maybe don't go so long, don't go for so long of a walk, head back home. Always adhere to your restrictions, keep an eye out, but the truth is that these are professionals. It's what they do for a living. So one would hope that they're good at not being caught. So if you're being surveilled, it could be that you don't know that you're being surveilled until it comes up in a deposition, in a trial, in settlement negotiations. Because, Alex, correct me if I'm wrong, but if it's a deposition, you're under oath, and anything that you lie about can get you in a lot of trouble, right?
Yes.
Perjury, which is lying under oath, is a felony here in the state of California. Carries a prison term and possible fines, as is lying in order to obtain workers' compensation benefits.
Yes.
So you do not want to be mixed up in that. Now, when you're sharing things on social media because you want it to be public, it's fair game. Anything you put out there on social media, the insurance companies, the adjusters, the defense attorneys can and best believe they will use it. They're going to use it. Why wouldn't they? Why wouldn't they?
It's subrosa. It's surveillance on yourself.
Yeah.
It's like being in a public place. When you're in a public place, they can film you. As long as they're in a public place, they can film you. So if you're on private property and the person surveilling you is on public property, they're allowed to surveil you. Even if you're in an area that says you can't film me, they're still allowed to surveil you.
Yeah.
Be sure to like this video and share it with friends and family if you believe that it will be helpful to them. And if you're a worker and you'd like to learn more about your legal rights, every week you should subscribe to our channel and hit the notification bell. You will gain valuable insight that will protect you and other workers and family members and friends from being taken advantage of when they're injured at work.